Let me begin by saying that corrupt judges are worse than armed robbers. But even armed robbers have their day in court. In other words, you cannot violate the law in order to prosecute a legitimate war against corruption. I am not favorably disposed to the way and manner the Department of State Security went about carrying out its mission. Aside from the dubious legality of the jurisdiction of the DSS in corruption matters, going to invade the premises, residences of judicial officers in the thick of the night is a little bit unsavory. I'm not saying that the law does not permit searches anytime, because we have a Criminal Jurisdiction Act of 2015, which has departed somewhat from the previous understanding that a man's home is his castle. That's a notion that goes back to 1215, the Magna Carta Angliae. So the law in 2015 in Nigeria permits searches any day and any time. But you see, a little dignity should be upheld in the prosecution of this type of case. Don't forget, judicial officers are sworn to do justice to all manner of persons without fear, without affection, fear, or ill will. So if they are caught violating their judicial oath, then of course they deserve utmost treatment within the judicial process. But the problem is that it seems that the DSS wants to set up itself as being above the law, and that is where I depart from them. If you are operating a system of the rule of law, democracy, separation of powers, presumption of innocence, all the advantages of what you call adjectival law in terms of enforcement, it's not proper for any arm of government to be acting as if it was above the law. So whilst I'm against corruption in all its ramifications, I don't think it's right or proper to step on blood in order to carry out a crusade against corruption. Well, the NJC was a creature of the Constitution to supervise the appointment of judges and the functioning of judiciary, including discipline of the judiciary. The NJC is not expected to try judges, but to receive petitions and investigate activities of suspect judges. And if the allegations are proven, then the NJC is authorized to separate such judges from the judiciary. Then, having removed such judges from the judiciary, of course, it's perfectly within the jurisdiction of the Nigeria Police, the EFCC, or the ICPC to institute prosecution against those who have been found wanting. So if the people feel that the NJC has not been acting conformably with the Constitution, that does not authorize extraordinary actions by the Department of State Security against judges. Now, if we had a revolution, that would be perfectly in order. If a revolution had occurred in Nigeria, then we could use untoward means to deal with those who have been found wanting. In other words, a revolutionary situation permits the suspension of due process of law and actions that are necessary, thereby authorized to be taken pursuant to the revolution. But the last time I checked, Nigeria had not become a revolutionary polity. Then I think it's the way and manner Nigerians carry out their activities. Last year, nearly 30 judges were dismissed from the judiciary in Ghana without the histrionics and the brouhaha that we have experienced. So why is it that Nigeria cannot do things properly? Why did the EFCC and ICPC abandon their jurisdiction to DSS? DSS is to take care of treasonable acts, felonious acts, insurrectionist acts, acts that might bring the government of the day down, not corruption. I know corruption is definitely a cardinal sin amongst those who are progressive-minded. But with the same token, there are other principles, like presumption of innocence, okay? Then don't be a judge in your own cause. The way the DSS has been explaining or justifying its activities is tantamount to trial by ordeal, not trial by due process. Trial by newspapers, by the media, in violation of one of the sacrosanct principles of criminal justice, audi alteram partem. Hear the other side. Nobody has heard the other side from those judges. I presume that in fullness of time they will have their day in court, when we will now be in a position to hear their side. Because people are rushing to judgment, defending the indefensible, just because they think that it should be my government right or wrong. Some of us are not persuaded. In fact, some of us who deprecate such activities, we are paying compliment, to quote William Fulbright, to our country. Critics are not enemies of the state. They want their countries to be better governed. So whilst the crusade against corruption is laudable, is altruistic, is patriotic, I think those who are at the front line of the war against corruption must be sensitive to the niceties of due process of law.
This is not the first time that some hard methods will be used to get people that this government, this particular administration, had tried to, bring to book concerning corruption. And then we have also seen, for example, the cases of Olisamitu, Dasuki, and the rest of them who are denied bail. In fact, whenever they are granted, they are picked up immediately again for another offense and detained. But even though there were criticisms too of that method, it didn't generate as much reactions like this from especially the elites in this country. Would you say that was fair and the one against the judges isn't fair, or would you criticize everything altogether?
Well, one of the things that we lawyers celebrate is that similar cases should be treated similarly. So the case of the former National Security Advisor, that of the spokesperson of the PDP that you mentioned, are quite different from the case of judicial officers who are accused of corruption. And interestingly, Olisamitu was in the same ward as I was in hospital, because the court did not allow him to go abroad for his treatment. And it was a special private ward, so I don't think he will be very much angry with his admission to that. What happened with the NSA, the then NSA Dasuki, Colonel Dasuki, is what nearly brought Nigeria to a stop in terms of misappropriation and misapplication of security funds by those who were to procure arms and ammunition to prosecute the war against Boko Haram. I'm aware that the Community Court of Justice of ECOWAS had since granted reprieve to Colonel Dasuki. And we're all waiting to see how Nigeria will react, having signed onto the ECOWAS Treaty, the Lagos Treaty of 1975, and the Cotonou Treaty of 1990. So what we are saying is that to the extent that Nigeria is signatory to treaties, Nigeria is bound to carry out the decision of the Community Court of ECOWAS. Just like Nigeria felt bound to carry out the decision of the International Court of Justice in respect of the dispute concerning the delimitation of the boundary between Nigeria and Cameroon. So it's a question of the sanctity of international law, okay? But again, maybe that's not directly concerning us, because I'm aware also that Kanu, the leader of IPOD, has sued Nigeria before the Community Court. He's asking for $800 million. I know the Agatu farmers in Benue have also gone to the Community Court of ECOWAS. It seems that there might be a floodgate opened to Nigerians bypassing the courts in Nigeria and, in fact, completely shunning the principle of exhaustion of local remedies. In international law, generally speaking, before your matter could be justiciable before an international tribunal, you need to have exhausted the judicial process, all the courts, the systems, right up to the Supreme Court. It's after the Supreme Court has spoken that you can take your matter before the Community Court of ECOWAS. In fact, the Community Court of ECOWAS until 1995 did not have that power. Or 2005, I think, yes, did not have the power to entertain applications from individual litigants against their state of nationality. But we seem to be following the approach of the European community, because the African Charter on Human and People's Rights, the ECOWAS Treaty, and all those things want to fulfill an international minimum standard, or what you can call international best practices. So Nigeria has to be careful. It's a reputable member of the international community. And if it does not wish to be declared a pariah and isolated because of disregard for judicial orders, then it has to shape up. If Nigeria does not want to behave like Burundi, that has walked out of the ICC, Nigeria will not walk out of the ECOWAS. The headquarters of ECOWAS is in Asokoro. The Community Court of ECOWAS is in Abuja. And Nigeria is the #1 financier of ECOWAS. So I loathe to see the day when Nigeria will exit ECOWAS because of unfavorable judgments. Jammeh of Gambia can behave like that, but I'm not sure Buhari will want to go down in the list of the discredited when judgments are no longer predictable. It depends, by and large, on the man with the larger wallet. So it's not an edifying moment for the Nigerian judiciary. So quite sincerely, I think I first thought that the action of the DSS was prompted by fifth columnists who wanted to embarrass the Buhari government. But from what we've heard in the past week, it seems the government was at one with the DSS. At least we follow what the Attorney General of the Federation said. And don't forget, the Vice President of Nigeria is a law professor and a senior advocate of Nigeria. If they did not endorse what was done, they ought to have called the goons to order. That It's not right. Don't cut your nose to spite your face or throw away the baby with the bathwater. So we have to do things with requisite decency, act in a fit and proper manner, even when we are seeking justice. You cannot destroy justice or the judicial process in order to enforce the law. The judges might have been guilty of robbing us of justice by bending the rules. You know, we have the notion of Themis, the goddess of justice, whose figurine adorns our courts. Blindfolded lady, holding the sword on the right hand and scales of justice on the left. What have corrupt judges done? They have removed the blindfold from the lady of justice and now tilted the scales in favor of litigants that have seen them, as we say in Nigeria. You know, so I'm all for anti-corruption, but within the rubric of due process of law. Because once you break the law in order to implement a law against corruption, then there will be no end to it. One of my friends called it a slippery slope. You know, the banana peel that we used to say. It's just not done, you know, the way we have carried it out. Well, I don't think I will be saying anything new separate from what the Chief Justice of Nigeria said, that it was a most unwholesome assault on the bastions of the judiciary. Many judges will be cowed because of this and be looking behind their shoulders. They don't want to suffer the fate of their brethren. One of the judges, for instance, was my student, Chief Judge of Enugu State, who was even an academic. He was a lecturer in UI. And I don't know, I still believe that Innocent Umezulike should not have caught himself in such an embarrassing situation. Justice Oyebode of the Western Nigeria Court, I've mentioned Kaudia Shaw, Chukwudifu Oputa, Andrews Oputu Obaseki, judges of that caliber. It could not cross your mind that they will be caught with their fingers in the pot. So what has happened now has lowered the estimation of ordinary Nigerians of their judicial officers. And a lot of work will need to be done to restore the judiciary to its position of pride, respect, and integrity. That, I think, is the sad, maybe unintended consequence of this assault on the judiciary.